Good afternoon, everyone. My name is Catherine Lucidi. I'm the Director of Community Relations at Legal Services of Long Island. I'm filling in for Sharon Campo today, so have a little patience with me. I'm new at this part. So the title of today's seminar is Weather in the Storm, Navigating Student Loans in Uncertain Times. And we are lucky enough to have Nancy Neerman, the Assistant Director of EDCAP, who will be teaching everyone and letting everyone know what's the new updates on student loans. This is the following agenda. We're just going to go a little bit over about Legal Services Long Island. We're going to start now. So we handle about 6,000 legal cases every year, and that's through phone consultations, direct representation, brief services, referrals. We have 3 locations, Hempstead, Islandia, and Riverhead, and our staff is comprised of attorneys, paralegals, social workers, and let's not forget the receptionists as they answer the phones every day. And we have partnerships with community agencies as well. This is our contact information. You'll find a lot of great resources on our website, legalservicesli.org. Hempstead is for Nassau County residents. Islandia is for residents that live west of 112. The Riverhead office is for residents that live east of 112. They do accept walk-ins, but we do suggest you call first if you're referring a client over. These are the different programs that we handle. Our family law, domestic violence family court project, the Child Support Defense Project in Suffolk County only. And then we have disability and health related projects, our HIV unit, our mental health unit, those who are suffer from severe and persistent mental illness. The ICANN project, they assist with managed long-term care. Education and Disability Rights Project, that's for special education rights of developmentally disabled children. We also have the Disability Advocacy Project. We help with appeals for Social Security disability and supplemental security income. Our housing unit, one of our biggest units, the eviction prevention, foreclosure prevention project as well. The other specialized units are consumer debt, veterans rights, human rights project, public benefits, adult care facilities, senior citizen law project, which is only in Nassau County. The Pro Bono Project is in Suffolk, and the Volunteer Lawyers Project in Nassau County, and the Community Legal Help Project, and that is in both counties. I work in the Legal Support Center for Advocates, so if you ever have any questions for your clients or you have your client with you, you can call me. My extension is 3324. You can call Sharon Campo at 3368 and Hannah Fitzpatrick, wave hi Hannah, at 3343. It's a service for advocates only, so please don't give our extensions out. We are here to assist the advocates. Clients can call the general number directly. And as you can see, we get calls from legislative staff, social workers, outreach workers, guidance counselors, medical personnel, school districts. We host the community trainings, and we also publish the newsletters. And now I'm going to turn it over to Nancy Neerman. Thank you again, Nancy, for doing this seminar for us today. And she will go over some of the housekeeping issues.
Thank you, Kathy, and thank you again to LSLI for allowing me to come and present to you. So just a few housekeeping measures. We are here with a number, aside from Kathy and Hannah, Vivian Storm, who is the attorney that works on the EDCAP project at Legal Services of Long Island. If you have any questions during the presentation, feel free to put them into the chat, and Vivian will be behind the scenes trying to answer your questions in the chat. We'll periodically break to share those questions and answers with the rest of the group, and at the end, there should be some time for any residual questions. So with no further ado, I'm going to start the presentation. So I'm going to start with recent developments. As you probably know, there's been a ton of information coming out over the last few weeks regarding student loans in the Department of Education. So I'm going to make an effort to break all that down for you and just kind of focus on the key and important points. So You have probably read that there have been mass layoffs at the Department of Education. Probably at least half of the staff is gone at this point, and our understanding is that there's another round coming in the not too distant future. This is all part of the current administration's efforts to dismantle the Department of Education and generally cut federal employees across the board. So there have been some key areas that have really been sort of gutted as a result of these as a result of these reductions in staff. And that would be the folks that oversee the loan servicers, the Ombudsman Group, which is a group that we work with very closely during the Biden administration, that were able to help us um, in in resolving people's disputes with federal student aid or their servicers. Also, the technology folks have been fired as well. So that could have some repercussions for the functioning of the federal student aid website or the processing of certain applications going forward. So stay tuned. But because they have really kind of gutted the departments that were there for borrowers' assistance and were there to receive complaints. And it doesn't mean that you can't file a complaint with the Department of Education. You should on federal student aid. But in addition to that, if you've got complaints, in New York, you can file those complaints with the Department of Financial Services. And because the Consumer Financial Protection Bureau, the CFPB, has been gutted as well, or effectively neutered, and that was the other avenue for filing complaints. The Student Borrower Protection Center has developed a toolkit to help borrowers and help advocates understand the process for submitting complaints to elected officials like congressmen. So the elected officials are probably going to be hearing a lot more from student loan borrowers going forward. We've also, of course, got the announcement of the transition of the student loan portfolio to the Small Business Administration. To the best of our knowledge, they can't do this without without congressional approval. Doesn't mean that they won't try, but it's our understanding that they're going to need congressional approval to do this. So nothing has changed right now. But stay tuned, because they're probably at some point going to attempt this transition. The one thing to be aware of is that if the loans do transition over to the SBA, nothing about the loans themselves are going to change. So the loan details don't change, your balances don't change, your interest rates don't change, the repayment options, the forgiveness options, those all stay the same. It's just the folks overseeing the loans may wind up being different. So the most recent announcement was just in the last few days, was the announcement that collections would start on defaulted loans. So the department in their press release said that they were going to start the collection process for for offsets, so Treasury offsets. That would be tax refund intercepts and Social Security offsets on May 5th. There are about 5.5 million borrowers that are still in default. Most of those were probably in default prior to the pandemic. But during the pandemic and for about a year and a half since the payment pause ended, collection activities on defaulted loans have been suspended. So they're about to turn the switch on. And I should say that this is largely in keeping with the timeline that the Biden administration put out just before they left. What will probably happen is that the notices for Social Security offsets and tax refund intercepts will go out on May 5th, but the actual collections probably will not start till about a month later. Administrative wage garnishment, they said they're going to send notices at the end of the summer on those, which means that that will not, actual collections probably won't happen until sometime in late September or October. It's not 100% clear whether they're going to send new notices for people who already had been notified prior to the pandemic. They should clearly do that. Whether they do or not, it's not explicitly clear. So the bottom line is, I'm sure that, and we're already starting to see it, I'm sure that now that people are going to be faced with money actually being taken from them, there are going to be more people reaching out for help. There is a Treasury offset program phone number that you can call that I have here in the deck to determine if somebody is actually scheduled for an offset. So you can use that with your client to see whether or not something imminent is going to happen. Our understanding is also that they're not going to claw back tax refunds that have already been distributed for the 2024 tax year, but if you have clients that haven't filed yet, they might be in jeopardy. Borrowers should know that there are still ways to get out of default. You can do loan rehabilitation, which means that you make 9 monthly payments on time and in full over a 10-month period, or you can do a loan consolidation, which replaces the old loans with new direct consolidation loans. But the general message, of course, is if anybody's is in default and needs help, they should reach out. They should reach out to LSLI, who are equipped and are experts to help them, guide them through this process. The SAVE litigation. So the SAVE plan, which was the cheapest repayment plan for most borrowers that was introduced by the Biden administration, has basically been halted since last July after a series of lawsuits that were filed challenging the Biden administration's authority to create this plan. A recent court ruling from an appeals court basically upheld the injunction. Last July, the courts basically barred the administration from enrolling anybody in the SAVE plan, from allowing people to make payments in that plan. And as a result, anybody that was in SAVE starting July of last year was placed in a forbearance. It's a non-interest-bearing forbearance that does not count towards forgiveness. And as a result of the most recent court ruling, they will remain in that forbearance at least until July 31st of 2025. If the court issues are not resolved by that date, that forbearance will continue to be extended. But the Court of Appeals has basically thrown the case back to the lower courts for what hopefully will be a final decision, and hopefully sooner rather than later. For a period of time after the most recent court ruling, the current administration took down the IDR online and paper applications, so you couldn't even submit them. The application process is open again. There's a new PDF. There's the online process is there. You can submit the applications, but to the best of our knowledge, they're still not processing anything. And there's probably at least 1 million applications in backlog. So when they do start processing, which they seem to be indicating is going to be next month, it still could take a long time for these applications to process, but you can at least file them right now. IDR forgiveness, that's forgiveness that you get by virtue of just being enrolled in one of the income-driven repayment plans. We're going to talk more about this later. This is a program that requires that you be making payments in one of these plans for 20 or 25 years, after which balances are forgiven, and there's no employment requirements for that program. Forgiveness through IDR, however, seems to be on hold right now, and we'll have more details on that later. Consolidation applications are being processed both online and by paper, but you want to be careful about consolidations. Generally, people who consolidate loans also want to enroll in it. Oh, can I ask everybody to please mute your microphones? Thank you. Online consolidation applications are being processed, but generally people who file for consolidation also want to enroll in an IDR plan, and right now it may take a long time to get into an IDR plan. So you want to be careful about consolidating at this point. And PSLF remains in place despite all the headlines. Nothing has changed about this program. Borrowers who are not in the SAVE plan can continue to earn credit towards PSLF if they're enrolled in PAYE, IBR, or ICR. So recertification guidance, as you probably know, income-driven repayment plans generally need to be recertified annually. Recertification dates have been continuously pushed back because of the pandemic and then because of the litigation. But there was this period in February when the department shut down the IDR application process. Borrowers that were in PAYE, IBR, and ICR may have been required to recertify in February, but they were not able to do so because the IDR applications were not being processed. So some people were not necessarily kicked out of their plans, but their payments were reset to a very high level that they could not afford. The department just issued, like a few weeks ago, they finally issued some guidance on recertification. I'm not going to go through every single point here. You can read this when you get it, but I will highlight that all recertification dates, this is for direct loans and FFEL loans held by the Department of Education. All those recertification dates were pushed back or should be pushed back to at the earliest February of 2026. The SAVE recertification dates have already been pushed back. And a lot of the adjustments, if you fell into one of these categories, are supposed to happen automatically. Like they'll push your recertification dates back. If you were placed in a high payment plan, they're in some cases going to try to reset you back to your original IDR plan. But if you were required to recertify on or before February 20th, and you weren't able to do so and your payment adjusted upwards, you do have to file a new recertification application. You should do that online as soon as possible to make sure that your account is adjusted properly. And for any of these other situations where they say that it's supposed to be done automatically, you just want to monitor your account to make sure it does get done properly. If you need to, you may have to call the servicer or reach out for help. Potential changes coming down the pike. So there's different ways that changes may be affected towards student loans. The first and foremost is going to be the legal, as a result of the legal challenges when this court case is finally resolved. It's highly likely, and I mean like 99.9% likely, that the SAVE plan is going to go away. We don't believe it's going to survive the litigation. There are other regulations that may impact other IDR plans that may be struck down as a result of the court ruling as well, including automatic IDR recertification, weighted average retroactive credit towards IDR forgiveness when you consolidate. It's still to be seen. We have to wait for the result. The courts may also make a determination that IDR forgiveness cannot be offered through payee or ICR. Now, that doesn't mean that payee and ICR payments will not count towards PSLF. PSLF is a separate issue. It's not part of these court challenges. And the PSLF regulations explicitly state that payments in any of the income-driven repayment plans will count towards public service loan forgiveness. The IBR plan is the only plan that is in statute, meaning that it's a law. It was authorized by Congress, and it should not be materially affected by these court rulings. Beyond the legal challenges, there are two other processes that are happening. There's the budget reconciliation process that is going through Congress, and something called negotiated rulemaking, which is a process that the Department of Education uses to create regulations that could make some significant changes to student loans going forward. The negotiated rulemaking process, which is starting to get underway, is a long process. If there were any changes as a result of this, you probably wouldn't see them become effective probably for about a year, but you never know. They may try to push things through faster, but generally that's the time frame. So some of the things that could happen as a result, and we don't know for sure, but we don't know for sure what's going to happen with budget reconciliation, is replacing the current repayment options for future borrowers with only two plans: the standard 10-year fixed plan and some version of an IDR plan that would probably not provide forgiveness, which is just generally confusing to a lot of us, but we'll have to see. That could result in many low to moderate income borrowers with larger balances basically being stuck with that debt for the rest of their lives if they didn't have PSLF or teacher loan forgiveness or other forms of discharge as an option. They also are proposing making some changes to the existing plans, such as payee and ICR. They're talking about sunsetting PLUS loans. Those are the loans that parents and graduate students use to borrow up to the cost of attendance that allow you to fund your education within the federal system. If that goes away, people would be either forced to take out private loans, which are generally more predatory and more difficult to manage, or they just would not be able to go to these expensive schools. They're also talking about changing PSLF eligibility. This is the employer eligibility as per the president's executive order, and I'm going to go over that in a little bit more detail later. If you're interested in participating in the negotiated rulemaking process, because a portion of it is open to the public, there's a link here, and you can see where you go to sign up for that. So what should you do in the light of all these things that are either slated to happen or may or may not happen coming down the pike? The key thing we want to just like say to everybody at this point is you need to keep really good records. You can't really count on federal student aid or the servicers at this point to keep accurate records of your debt and all its details. So what we're encouraging all of our clients to do is start screenshotting and downloading all important information like loan details, both from federal student aid and the servicer accounts, payment history, which you get from the servicer accounts, information from the forgiveness program trackers like PSLF and IDRF, which are now on federal student aid accounts if they have them, and then important notifications from the servicer inboxes. And you should do this monthly, or if you receive a notice that your loans are going to be transferring to a different servicer or potentially to the SBA. Okay. Vivian, I'm going to stop there for a second. And are there any questions that you want to highlight for anybody?
Yes, one question. If borrowers are in the safe forbearance and are concerned that they may be accruing interest, what should they do to confirm whether or not that's actually taking place, and what remedies might exist?
Yeah, so we have definitely seen examples of this. It's a mistake. If you're in the safe forbearance, you should not be accruing interest. Now, but remember, there's a couple of things to keep in mind. If you had unpaid interest, if you had an unpaid interest balance before you enrolled in Save, that didn't go away because you enrolled in Save. It's only any new unpaid interest that accrues in Save that should not have happened once you were in the Save plan or in the Save forbearance. And particularly in the Save forbearance, because that's a non-interest bearing forbearance. So the way you want to make sure that you see whether or not this is happening is you have to monitor your unpaid interest balance from month to month. So unpaid interest balances in Save in the forbearance should not be changing month to month. If you see that it's $500 one month and then the next month it's $1,000 and the month after that it's $1,500, they're doing something wrong. You have to contact the servicer. You have to basically tell them that they're not doing something right and get them to fix it. And my experience is that they generally, once you prove to them that it's being done wrong, they will fix it, but you have to do it through the servicer. And if you can't, then you're going to have to start filing complaints, and I would suggest going through DFS for that. Anything else?
Nope, that's it for now.
Okay. Okay, so the next section, we're going to talk a little bit about just general strategy for getting rid of your debt. And what we have seen from dealing with thousands of clients since we started this program in 2019 is that most people fall into one of three buckets when you're talking about the long-term strategy for eliminating debt, because a lot of people will come to you come to us as clients with immediate needs, which of course we want to address. They can't afford their payment plan. They're about to go into default, or they're in default and they want to get out of default. And we address all of that, but we always want to leave our clients with some long-term strategy for actually getting rid of their debt. So people tend to fall into one of these three buckets. The first is pay your debt in full as quickly as possible, which is what most people think of when they take on debt. But this is going to be the strategy that's best suited for people that have higher incomes in comparison to their loan balances, so they're able to make a payment that's more than the required monthly payment, or make lump sum payments. If your goal is to pay off your debt as fast as possible, to pay off your debt in full, then you want to pay it off as quickly as possible. That may mean making higher monthly payments if you can, but the faster you pay the debt off, the more you're going to save on interest over the life of the loan. The second bucket is where most of our clients fall, and probably people that will reach out to you is probably what they would fall as well, is to pay the minimum required amount and pursue some forgiveness program that you may be eligible for. So there are very viable strategies within the federal student loan system that don't require that you pay your entire balance off. And that is by identifying these forgiveness programs that you may be eligible for, and then fulfilling the requirements of those forgiveness programs. So the two big ones are going to be public service loan forgiveness and income-driven repayment forgiveness. Income-driven repayment forgiveness is the one we talked about a minute ago, where you would pay for 20 or 25 years in one of the IDR plans, after which balances would be forgiven. No employment requirements there. PSLF is if you work an average of 30 hours per week for a qualifying employer, which is generally a nonprofit or a governmental agency. Your balances are forgiven after 10 years. So once you've identified the program that you're working towards, you just want to make the minimum required payment until such time as your loans are eligible for forgiveness. And then the final bucket, which sounds a little bit morose, pay the minimum required until death do you part. This is generally going to be for older borrowers who maybe have loan balances because they took out late in life loans for themselves, or they're carrying big Parent Plus balances for their kids. And they may be about to retire, or they're in retirement, so they really can no longer rely on things like public service loan forgiveness because they just don't plan on working much longer. They may be looking at making 20 to 30 years of payments to get rid of their loans. But if you're in your 60s or 70s, and we have clients all the way up into their 80s and 90s, that basically means you're going to be paying for the rest of your life. We do put this here for a reason, and you, of course, in this situation, you just want to find the cheapest option and make those payments until you pass. And the reason that we put this here is because a lot of people don't realize that, unlike most other consumer debt in the United States, federal student loans are discharged in death. So that just means that the burden and the obligation of the entire debt is not going to accrue to the decedent's estate or pass down to their beneficiaries. Okay, repayment options. I'm not going to go over this in too much detail, but just generally speaking, there are two different ways to make payments in the federal student loan system. There are the traditional repayment plans, which base the payments on the size of the loan, the interest rate, and the predetermined payback period. The fixed versions of these plans are like paying back any regular consumer debt. So it's like paying back a mortgage or an auto loan. You make the monthly payment over the time frame after which you've paid the entire debt, including all the interest. The alternative to that is an income-driven repayment plan, or IDR plan. And when we say IDR or income-driven, that's the umbrella term for these four payment plans that mentioned at the bottom: income-based repayment, pay-as-you-earn, income-contingent repayment, or the SAVE plan, or its predecessor, revised pay-as-you-earn plan, which currently is not in existence. IDR plans generally offer an affordable alternative if borrowers can't afford the traditional payments in the traditional plans. You may also be required to be in an IDR plan if you're pursuing a forgiveness program like IDR forgiveness or public service loan forgiveness. They're generally more flexible in the sense that you can adjust your payments if your income declines. The downside to the IDR plans is you do have to annually renew them and recertify them, and that can be an administrative burden and a little bit of a hurdle for some people, just in terms of keeping up with that. And also, of course, the interest, unpaid interest can accumulate and does accumulate in many of these plans if your payment doesn't cover the entire interest level, which is why you see people complaining about student loans. I've been making my payments for 10, 15, 20 years and my balance is going up. In those instances, most people should be pursuing forgiveness programs. So the goal is really not to pay the entire debt off. It's just to pay what you're required to pay until you get your forgiveness. And in terms of traditional plans, if you see the names standard, extended, graduated, or on your servicer accounts, if it says level, those are all versions of the traditional repayment plans. So income-driven repayment forgiveness, the 20 to 25-year forgiveness, the Biden administration had a program last year called the IDR account adjustment. It's actually had been in force since April of 2022, I think, but it took them a couple of years. What it did was it awarded retroactive credit towards IDR forgiveness based on a set of relaxed rules. At this point, trackers were placed on people's federal student aid accounts. They look like this. These are the IDR forgiveness trackers. Most borrowers, not everybody, but most borrowers have these to give you an idea to monitor your progress towards where you are in relative to IDR forgiveness. But keep in mind that IDR forgiveness, the SAVE plan is probably going to go away. IDR forgiveness in payee and ICR may not happen depending on what comes about as a result of the court rulings. But any accumulated credit in SAVE, payee, or ICR can be transferred to the IBR plan, if you're eligible for that plan to ultimately get your 20 or 25-year forgiveness. Now, the IBR plan is the only plan that is in the statute. It was approved by Congress, and it explicitly says that it will grant forgiveness after 20 or 25 years of payments. Right now, as far as we can tell, though, IDR forgiveness is paused. Seems like it's paused across the board, even in IBR, but eventually they should resume processing IBR forgiveness. TBD on the other on forgiveness through the other plans. Public service loan forgiveness, of course, is making the 120 qualifying monthly payments. So 10 years of qualifying payments. We went through the requirements a little bit earlier. Payments do not have to be consecutive. So they are cumulative. You can work for 3 years in a qualifying employer, then leave to go to the for-profit sector and come back. You won't lose your payments that you would, or your qualifying payments that you'd already accumulated. And you must meet the employment requirements at the time you submit your application for forgiveness. So if you're planning to retire in 2 months, and you're going to submit your last application, you want to make sure you're employed, meeting the employment requirements at the time that you submit that last application for forgiveness. And then, of course, forgiven balances are not taxable at the federal or state level in New York in the PSLF program. The IDR account adjustment that I just mentioned, one thing you should know about that is any qualifying payment credit that you got on that IDRF tracker can be converted to PSLF credit once you file the PSLF certification forms that verify that you met the employment requirements for those months. So you just want to make sure that you're getting the right credit. If you still have these older loans called FFEL loans, those loans had to be consolidated by June 30th of 2024 to get the full benefit of the IDR account adjustment. At this point, only direct loans qualify for PSLF. That doesn't mean that you can't ever get PSLF credit on your FFEL loans. You would have to convert them to a direct loan by way of consolidation first, and then you would start earning credit for PSLF. You will get no retroactive credit on FFEL loans for PSLF at this point. So if you're in this situation, I would strongly recommend that you reach out for advice before you do any kind of consolidation right now. There's some other factors that make the situation a little bit complicated, and we would want to look at the account and just make sure that you're doing the right thing. You should be aware of the fact that there are consolidation rules pertaining to consolidation that apply to PSLF that are in effect right now. And I know this is what gets people very confused about this process, because there's different rules for the IDR forgiveness program and those for the public service loan forgiveness program. So the public service loan forgiveness program, once again, that's a law. That's also a congressionally approved program that was not part of the SAVE program and not part of the SAVE litigation. So the SAVE litigation is not going after PSLF in any way. It does go after the IDR plans that you need to get your PSLF credit, but it doesn't go after the PSLF program itself. That may come with some of the other things that we talked about, like budget reconciliation, negotiated rulemaking, but not through litigation. So there is a rule that's currently in effect that says that anybody that's got accumulated credit for public service loan forgiveness on their direct loans that is looking to consolidate will get weighted average retroactive credit towards PSLF post-consolidation. So the old rules from a long time ago used to be that once you consolidated your loans, any accumulated credit that you had towards public service loan forgiveness would be lost upon consolidation, and you would have to start accumulating new credit from scratch based on that new loan. The new rule is that you get this weighted average retroactive credit if you consolidate, and let me explain how this works. Let's say you have two direct unsubsidized loans, each in the amount of $50,000. One has 40 months of qualifying payment credit towards PSLF. The other has 60 qualifying months of payment. Once you consolidate those loans, you will have one direct unsubsidized consolidation loan with a balance of $100,000, and that loan will have 50 qualifying payments towards public service loan forgiveness. So you're not losing retroactive credit overall. It's just giving you weighted average credit, which this can be actually an effective and beneficial thing to do if you've got loans that are on different PSLF schedules. Again, you would want to reach out for some help with this to make sure that this was the right strategy for you. But it can be done. The one thing that you need to do though is you need to make sure that your qualifying payment count is updated on all of the loans that you plan to consolidate before you do the consolidation. So you want to file that PSLF certification form to verify your employment, get the updated count, then you can do the consolidation. Now, we've been telling people to kind of hold off on consolidating for this reason right now, just because the IDR applications are not available and well, they're available, but they're not being processed. And we didn't want to get particularly people that may be already accumulating credit in payee or IBR or ICR. You can always do this in the future once the IDR situation is a little bit more normalized, because we just don't want you to get stuck in a position where you do the consolidation, then you're waiting many, many months to get into your new IDR plan to continue accumulating credit towards PSLF. The PSLF buyback is another rule that went into place in 2023 that allows you to purchase PSLF credit from months that you spent in a disqualifying status. So if you were in some kind of forbearance or deferment that didn't qualify for PSLF when you were in those statuses, you would be, in theory, able to purchase those months back. But it has to be done under certain circumstances. So number one, you have to have 120 qualifying months of employment on record, not qualifying payments, but qualifying months of employment. So if you're just at that point where you're about to reach that, what you would want to do is submit the PSLF certification form, get all of your employment verified, even if it doesn't bring you to 120 qualifying months of payments, you would have 120 qualifying months of employment on record with the department. Then the months that you buy back must get you to 120 qualifying months. You can't purchase months prior to consolidation, and you can't purchase months spent in a school deferment, a grace period, or in default. And the payments are supposed to be based on the payments you were making in the IDR plan prior to entering that disqualifying status or immediately exiting after you exited the disqualifying status, if that even applies. You would submit the request through the PSLF reconsideration process. I have the link here. It's pretty simple at this point. You just select PSLF buyback option. You don't really have to give them any other details, and that's it. And then you sit back and wait. Couple of things to be aware of. Number one, we're really not sure whether they're processing these applications right now. They say they are in theory, but it's kind of up in the air whether or not they actually are. We're also not 100% sure that they're going to allow months in the save forbearance to qualify for the PSLF buyback. And so if you think that you're eligible for the buyback, you should submit the application. There's no downside to doing it, but just keep in mind those two different things. I wouldn't necessarily count on months in the save forbearance being eligible for the buyback. They may be, we're just not 100% sure at this point. Okay. I'm going to go through the guidance section and then we'll do questions after this. So guidance for borrowers in terms of where you are now. If you're in the save forbearance, you don't have to take any action right now. That save forbearance is in effect until at least July 31st. If the court case is not resolved by then, it will be pushed back even further. Your payments are paused. There's no interest accruing on your account. Now there are reasons that you may want to get out of the save forbearance, which we're going to discuss in a minute. But if you don't want to and you don't need to, you don't have to at this point. So you could take this time to explore what your other options will be, because at some point you will have to switch out of this plan. So you can be taking this time to think about what your other IDR options might be, and you can reach out to LSLI if you have any questions about that. If you're on one of those standard plans, so you were trying to enroll in an IDR plan, you were never able to make it in before everything shut down, just if you can't afford the payments in the standard plan, request forbearances. They should be granting them. You may have to repeatedly request those forbearances, which is a pain, I know. But if that's what you have to do, then that's what you have to do. You generally do that through the servicer. If you need to recertify your IDR plan at this point, if you have direct loans or FFEL loans that are held by the Department of Education, you shouldn't have to. Everything should have been pushed back to February of 2026. But if you just want to double check and make sure that you actually do have to recertify, and then if you do, see the previous recertification guidance. I will say, if you have older FFELP loans, what's called commercially held FFELP loans, if your servicer is AES or it had been Navient and those loans have now been transferred to Mohila and they're FFEL loans, that's a different, they're not adherent to, they're not subject to this particular guidance. Those recertification dates may happen at any time. So you'd have to check with the servicer to make sure that you are up to speed on what your recertification date is if you have that type of FFEL loan. If you want to switch between non-save IDR plans, which I think at this point most people probably don't, but if you do, we would suggest holding off on that until the IDR process is back online and they actually are processing applications, and we have an idea of what the timetable is for completion of those applications. For PSLF borrowers, if you're in payee, IBR, or ICR, continue making your payments so that you can accumulate additional credit on PSLF. For those of you that are in the save forbearance, now's the time, particularly if you're close to earning PSLF credit. If you're years and years away from earning PSLF credit, you might want to just remain in the save forbearance and see how things play out and see how they're going to move everybody from save to new plans going forward. We don't even know like what that process is going to look like. But if you're not and you're getting closer to PSLF, you're months away or even a year away or just a couple of payments away, you probably should be submitting an application to switch your repayment plan right now. We are recommending that you enroll in the IBR plan because that's the plan that is least susceptible to any of these changes that may come as a result of litigation. But if payee or ICR are cheaper for you, by all means, you can enroll in those plans and earn your credit towards PSLF in those plans. The other thing you should be aware of is that when you submit an IDR application, you're generally put in what's called a processing forbearance. A processing forbearance is a forbearance that suspends payments for a couple of months while the department or the servicer processes your applications. Processing forbearances are eligible for public service loan forgiveness for up to 2 months. Beyond that, you get placed back into some kind of a general forbearance, which is not, but you might be able to get a couple of months of PSLF credit just by being in a processing forbearance. If you're in the save forbearance and you submit one of these plans, you may have to call the servicer and request that processing forbearance, but it's worth a shot, particularly if you're within a month or two of getting your PSLF 120 qualifying payments. Submit the buyback request if you meet the requirements. This last strategy is probably not going to work for a whole lot of people, but payments in the standard 10-year fixed repayment plan, that's one of the traditional plans, count towards PSLF. If you're eligible for that plan and you can afford the payment in that plan, you could switch to that plan right now just by calling your servicer, and make the payments and earn your PSLF credit. That might be a strategy if you're within a couple of months of earning the 120 qualifying payments. But be careful, if you have a direct consolidation loan with a balance that's over $7,500, you're not going to be eligible for the 10-year version of the standard fixed plan. If in that case, you would only be eligible for extended versions of the standard plan, and they don't count towards PSLF. Again, you might want to reach out for a little bit of help on that before you move on that strategy. You should continue submitting your PSLF certification forms to verify your employment. You want to do that annually or whenever you change jobs. Remember, only payments from October 1st of 2007 or later will count, because that's when the program started. But I want to really make it clear, and I can't emphasize enough, that you want to use the PSLF help tool that's on your federal student aid account and request an electronic signature from your employer. This is an option that you have now. A couple of years ago or a year and a half ago, this wasn't an option. Everything had to be signed manually. If you use the electronic signature process through the PSLF help tool, these applications and these forms are getting processed pretty quickly. So you'd see a relatively quick update in your employment and in your qualifying payment count. Anything that's submitted with a manual signature is sitting there for months and months and months. So if at all possible, you want to use that PSLF help tool and request an electronic signature from your employer. And then you want to monitor your progress towards PSLF using the PSLF tracker that's now on your federal student aid account. And then just the last slide that I just wanted to mention, for total permanent disability, TPD, this is not a new program. It's been around for a long time. It allows borrowers that have some kind of mental or physical disability that prevents them from earning a livable wage, essentially from getting their loans discharged. But the process for submitting the forms has changed. It's moved from Nelnet now to the Department of Education. There's a little bit more instruction here in the presentation on where to find the new process, and how to go about submitting these applications online. You could still submit them manually as well. So with that, you can contact Legal Services of Long Island. This is their contact information if you need additional help or guidance. And I'm going to stop it there and see, Vivian, if there are any other questions that we want to share with everybody, or let people ask a few residual questions.
There is a question particularly about taxability of IDR forgiveness.
Yeah, so after 2025, after this year, IDR forgiveness is probably going to revert to being taxable. And that's going to be the case with actually a number of forgiveness programs. So all forgiven or canceled debt, education debt, is excluded from federal taxation through the end of 2025. That was part of, I think it was part of the American Rescue Plan Act, which was a COVID era relief program. That ends at the end of this year. So IDR forgiveness becomes taxable starting in 2026. If that's when you got your IDR forgiveness, potentially it would be taxable.
There's a new question about the relative cost of an IBR plan payment compared to a SAVE plan payment.
So IBR is always going to be, well, generally speaking, it's going to be more expensive than pretty much payments in payee and IBR are going to be more expensive than they would be in the SAVE plan. The only plan that might be cheaper is ICR, and that's really only if you have high income compared to your loan balance, so a relatively small loan balance. IBR is going to be more expensive. So the SAVE plan calculated payments at, it was supposed to be, if it was fully implemented, between 5 and 10% of discretionary income, and discretionary income was calculated at your adjusted income minus 225% of the federal poverty level. That percentage of the federal poverty level is the amount of the payment that was amount of your income that was excluded from any payment. So the higher the percentage, the lower the payment was. The IBR and pay-as-you-earn plans calculate payments at either 10% or 15% of discretionary income, and discretionary income is adjusted gross income minus 150% of your federal poverty level. So it was more expensive on two different levels. And there's two different IBR plans as well. If your first loans were distributed on or after July 1st of 2014, you're eligible for the newer version of IBR, which calculates payments at 10% of discretionary income. If you have any outstanding loans that were dispersed prior to July of 2014, you're only eligible for the IBR plan that calculates payments at 15% of discretionary income.
There was a question I'm going to make a little bit more general. There was a question about whether somebody who's pursuing public service loan forgiveness should consider consolidating loans if the weighted average credit isn't going to be advantageous. I'm wondering if it might be helpful to give people in general an overview of when consolidation might be helpful and when they should avoid consolidation.
I'll try to do this as generally as possible, but I frankly think that if this is something that you're mulling over, you really do want to reach out for an individual consultation, because every situation is a little bit different. So when you're in an income-driven repayment plan, most of the income-driven repayment plans, the payment is based on, it's not based on the size of your debt, it's based on your income. And that payment isn't going to change because you have less debt, let's say. If you have $100,000 worth of debt and you're in the pay-as-you-earn plan and the payment is $400 a month, if you have only $50,000 worth of debt, the payment is still going to be $400 a month. So the extent to which you can shorten the period of time that you make payments overall on your debt, it is useful, because just because you have a lower amount of debt doesn't mean your payment is going to change. So what the consolidation process does, for the weighted average consolidation process does, it may shorten the total amount of time that you have to pay to get your public service loan forgiveness. Because remember, it goes loan by loan. Let's say you have one loan that has 100 qualifying months of payment and another loan that has 60 qualifying months of payments. In about a year and change, you're going to get rid of the first loan, but you're going to be still stuck paying on that second loan that you only have 60 months of qualifying payments on for another, let's say, 5 years. And if the payment doesn't change, then it would be to your benefit to do the consolidation, and overall shortens the amount of time that you have to pay on your entire debt. So I know it's kind of complicated, and I hope that makes sense. But if not, please reach out, because we can explain it to you probably better than I just did.
Nancy, there was a request for more detail on the executive order regarding public service loan forgiveness.
Yes, sorry. So the executive order on public service loan forgiveness that was out a couple of weeks ago basically is targeting restricting or reducing or eliminating employer eligibility if your employer engaged in certain conduct. And they said if your employer is involved in promoting illegal immigration, if they're involved in promoting illegal discrimination, which translation, that's DEI. They talked about the nonprofits that promote terrorism. I don't know what 501c3 nonprofits promote terrorism, or child abuse, which I think what they're getting at there is gender affirming policies. You can read the executive order when you get the deck. There's a link to it there. These are proposals. Well, this is their intention, obviously, without a lot of detail on how they would actually apply these standards. So what does that mean exactly? Does that mean that any organization that may be, you know, a legal organization that supports or has a client who's an illegal immigrant is not qualifying for PSLF? We don't know. The other thing is that within the PSLF regulations themselves, it states that all 501c3 organizations are eligible. It doesn't distinguish in terms of what they do. So we don't know whether they're planning to go after organizations that are not for profit but don't have a 501c3 status, maybe some other type of non-tax exempt status that requires that you have to be a little bit more explicit about the types of services that you provide, or whether they're going to try to make some kind of a general rule and apply it to existing 501c3s. We just don't know. I will tell you, though, that things that come out of the negotiated rulemaking process can be challenged by the courts. That's exactly what happened to the SAVE plan. So just because they do it, or just because they propose something in negotiated rulemaking, doesn't mean that it won't be challenged if it looks like they've gone a bridge too far or done something that just looks like it's contradicting the regulations that are in place.
I think that got all of our questions, or let me just check and see if there's something new. I think that's it. So
Okay.
we finished exactly on
I
time.
did it.
Thank you so much, Nancy. That was amazing. You're just such a wealth of knowledge on student loans. We really appreciate you doing the seminar for us. If you didn't receive the PowerPoint and you'd like to receive the PowerPoint, if you signed up late, you maybe didn't receive it. You can email me at clucidi@legalservicesli.org and I will get it over to you. And thank you everyone for attending.
Thank you, everyone.